When you have a temporary visa, that means you have a limited period that you are authorized to stay in the United States. And that period is given to you when you enter at the port of entry. Even though your visa says you can stay, you can enter the U.S. for up to 10 years, when you come into the U.S. and they stamp your passport, they may say you only stay for 3 months or 6 months. So when you enter the U.S. and your employees are coming, let them know they need to look carefully at that document when the guy stamps it. If they think they're staying for 6 months, maybe they're wrong, because that guy might have wrote 3 months on there. That's an important thing to do. I always warn people. Have a look, and if the guy made a mistake, I've had cases where the immigration officer writes the date of the next day. Well, how's my guy going to leave the next day? That's impossible. So it's a big headache to fix those problems once they exist. So it's good to fix it in the moment it happens. Hey, immigration guy, I'm supposed to be allowed 6 months, I think. Oh, you're right. Then they fix it right there. It could be a nice way to solve a big problem, prevent a big problem. All right, so they mark the date you must leave on the I-94 card. Some visa categories do not have a date specific you must leave. Like the student visa doesn't say you must leave on this day. Why? Because they don't know when you're going to finish your degree program. So they write D/S. What does that mean? Duration of status, duration of stay. That's just the period that you are studying and that you're being a good boy in your program, you're allowed to stay. And after that's over, you must leave. Overstaying a DS as a student has different consequences than overstaying the date of an I-94 expiration that is given on a date certain. And that's just something else you might be aware of, something in the back of your mind to consider down the road if that comes up. Now we'll talk a little bit about permanent visas. Usually obtaining a permanent visa or an immigrant visa begins with a process called labor certification, also known as PERM. Now in the United States back in the 70s there was a hairstyle. It was called PERM, and it was huge. Have you heard about that, the PERM? Afro, kind of like that, like big curly hair? Okay. Anyway, this is not what we're talking about now. PERM is the process for the Department of Labor, where the employer shows the Department of Labor that they have tried to be fair to the U.S. workforce. They have tried to recruit for U.S. workers to fill a position that they want to offer to a foreign national, an alien. But they were unsuccessful. And so the PERM process says, this is our foreign national, here is our job, here is the proof that we tried to find somebody by recruiting in the newspaper, maybe through other sources like the internet, headhunters, internal referral programs, things that some of you are familiar with if you've been involved with HR or staffing at all. There are all these common ways that you try to find a worker. And so you show the Department of Labor that you looked and looked, but you couldn't find an individual to fill this job. Okay? That's called a good faith effort, that they looked for the U.S. worker under good faith to find somebody, but were unable. Once the Department of Labor agrees that you looked for the U.S. worker and that the job is a real job that exists somewhere, and that you're willing to pay the prevailing wage and all of that, then comes the next step, which is what? Some of you experts out there. The immigrant visa petition, or it's also known as the I-140. Again, I-140, you'll hear about this, you'll work in the H-1Bs, the Bs or the L visas, but every now and then someone's going to say I-140 and you're going to know what that means now, if you didn't already. I-140 comes after the labor certification process, and it is where the employer shows that the employee is actually qualified for the job that is offered. So if the job requires master's degree plus experience or plus a certain type of technology skill level, at the I-140 stage, the employee provides the documentation to support that they have that skill or qualification. Also, the I-140 shows the government that the employer has enough money to pay the employee who is being offered the position. This will not be a problem for most of you because you come from big companies, but for smaller companies who are not succeeding, or if there's a huge loss in a company or other things, this can become a challenge, and that's where I get to do some of my fancy footwork. Okay? Now, after the I-140, or sometimes if there is a visa number available, and that's something we'll cover just briefly, you can begin the final stage. Visa number available, priority dates. Let me backtrack here just briefly. The priority date for employment-based immigrant is set by what event or events? Okay. The date the labor certification was filed for the beneficiary, or the date that an immigrant visa petition was filed, depending on if there was a labor certification in the first place. Some people get to skip over labor certification, which is that first step we talked about, proving that they recruited for the job. Some jobs are high enough level that they don't make you do all of that. Okay? Some jobs, they just let the person go right to the I-140, and that would be the date for their priority date, the date I-140 was filed in some cases. So priority date is important in the green card context because it sets the date by which you can measure when a visa number will be available for that applicant. This is a complicated area, and for you who process H-1s, Ls, or B visas daily, this will make your head hurt, okay? Sometimes it even makes my head hurt. But what happens is, and we can explain again briefly, priority date is important because it puts you in a place, in a waiting list, to get your green card or your immigrant visa. Typically, all of the applicants who apply from employer-sponsored immigration petitions are going to fit into one of these three categories: EB1, 2, or 3. Again, these are terms that you'll hear as you process cases: EB1, 2, or 3, and the employees are asking, am I EB2? Could I be EB2, please? Because they don't want to be EB3. Why? EB3 has a huge waiting list. Okay, the government in the United States is giving green cards or permanent residence to people who started EB3 back in 2001 from India. There's a quota system. And that quota system is so backed up for people who are skilled and professional, H-1B type workers for the most part, bachelor's degree required, maybe a little bit of experience. There's so many of these coming from India and China and some of the other countries that there is a giant backlog. There's a waiting list. And so the date that you filed your labor certification becomes important. Your priority date becomes very important. And again, there are tricks to getting earlier priority dates. There are certain ways that immigration lawyers have to try to categorize a person in a higher category to fit them into a higher level so that maybe they could advance through the green card process a little faster. EB2 process, EB2 preference category is for people whose job requires master's degree or bachelor's degree plus 5 years experience in their field. Now, it's not just that the person has that, it's also that the job must require that. And that's a difference. Some of your employees will come and say, shouldn't I be EB2? I have a master's degree. Maybe not, because your job doesn't require a master's degree. When you were hired under the idea that only a bachelor's degree was required. It's nice that you have a master's, that's great, and they give them a pat on the back, but they don't give them EB2. They may be only EB3, and so they'll wait longer for the green card. Questions? That's an area, again, that it's deep waters there, murky, you know. But that's something that I think it's good to know just generally what people are talking about when they mention these things. Oh, EB1 would be like Albert Einstein, you know, super genius type people. And there are a few of you out there, but it's not very common that somebody fits into that category, and there's not usually a waiting list for those people. Even the master's degree list is a few years ahead of the EB3 list at this point. So, you know, if you can fit somebody into the higher categories, it really makes a difference for them, often how long they wait for their green card. Permanent residence application is filed after, typically, these other two steps have been completed. Or if they're in a category where the priority date is current and there's no backlog, they can apply for the final stage of the green card